A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a significant legal showdown, environmentalists and traditional owners are intensifying their fight against Woodside Energy's ambitious gas production plans that could extend until 2070. After failing to persuade regulators to reject the oil and gas giants' proposals, these groups are now turning to the courts to seek justice and protect the environment. This week, the federal court dismissed a case brought by Doctors for the Environment Australia, DEA, against the federal offshore regulator and Woodside concerning the Scarborough gas project in northern Western Australia. This ruling marks a pivotal moment in a week filled with multiple legal challenges against Woodside's operations. The DEA had argued that Woodside's environmental plan was insufficiently detailed and did not comply with the standards set by the National Offshore Petroleum Safety and Environmental Management Authority, NOPSEMA. They expressed concerns about the project's potential greenhouse gas emissions and its impact on climate change. However, Justice Sean McElwain ruled that it was not within the court's jurisdiction to assess the merits of NOPSEMA's decision, stating that it was open for NOPSEMA to approve the environmental plan under the guidelines of Australia's offshore laws. Following the ruling, Woodside released a statement asserting that the decision affirmed the environmental credentials of the Scarborough project, which they claim will be one of the lowest carbon intensity sources of liquefied natural gas, LNG, for North Asian markets. Meanwhile, two other legal challenges against Woodside's operations remain unresolved. The Friends of Australian Rock Art, FARA, initiated a case against Woodside's Northwest Shelf Extension project, arguing that the WA government's approval violates the Environmental Protection Act by failing to adequately assess the project's contribution to climate change and its impact on the culturally significant Marujaga rock art landscape. FARA co-convener Judith Hugo expressed confidence in their legal strategy, emphasizing the growing momentum of legal actions against the oil and gas industry concerning climate change issues. Additionally, Marujaga traditional custodian Raylene Cooper has sought the court's intervention to compel Federal Environment Minister Murray Watt to address a heritage application lodged 3 years ago, which claims that gas emissions are degrading thousands of Aboriginal petroglyphs. The Marujaga cultural landscape, which includes over 1 million petroglyphs, was recently added to the UNESCO World Heritage List. Supporters of Woodside argue that the company's proposals are vital for ensuring a stable gas supply in the coming decades, particularly for industries reliant on high-heat manufacturing processes. Woodside maintains that it reserves 15% of its gas production for the domestic market as per state policy. However, critics point out that the gas exported to Asia is often framed as a cleaner alternative to coal, a claim that climate scientists contest due to a lack of evidence supporting such assertions. The legal battles surrounding Woodside's operations underscore a broader conflict between economic interests and environmental protection, as communities and activists rally to safeguard their heritage and the planet's future. As these cases unfold, the implications for both the environment and the energy sector remain significant, with the potential to reshape the landscape of Australia's gas production for years to come. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.